fun.
Okie dokie. Hi, everyone. Thank you all for being here on this Tuesday, the first day of September. Hopefully, you're all getting ready for a fun and safe Labor Day weekend. We are Russo Law Group, and we are back again for another live webinar, this time talking about common probate mistakes and how to avoid them. My name is Ashley, and I'll be helping to facilitate today's webinar. But before we do that, let's get to know our presenters, who are both partners with Russo Law Group, Marie Elena Puma and Eric Einhardt. Marie Elena is the senior partner and has been with Vincent Russo since 1991. Her areas of practice include trust and estate administration, elder law, special needs and estate planning, guardianship, and real estate. She has been recognized as a super lawyer every year since 2016. In 2017, she launched Russo Law Group's Alzheimer's and Dementia Caregivers Support Group, closely affiliated with the Alzheimer's Disease Resource Center. Finally, she has served on the board of the National Academy of Elder Law Attorneys, which we refer to as NALA, and the New York chapter of NALA. Now let's get to know Mr. Einhardt. As I mentioned before, Eric is a partner with Russo Law, and he's head of our guardianship department. He has recently joined NALA's board of directors, where he also serves as their editor-in-chief of the NALA News. He's also been recognized by super lawyers as a New York Metro Rising since 2016, and he's on the board of directors for the Nassau Cerebral Palsy Guardianship Corp. So that's pretty impressive resumes by both of you. Wow. I just want to remind everyone that this is a live webinar, and you may type your questions into the questions box provided on the Zoom toolbar. If you're logging in through Facebook, you can just use the comments section. Okay, thanks for your attention. I'll now hand it over to our presenters.
Thank you.
Thank you. Good afternoon, everybody, and happy September. Eric and I are pleased to be here today to present this program. We are going to cover several things today, but I wanted to just give you a sense of what the main topics are, which is 1, what is probate and when is probate necessary? 2, what are the common mistakes during the probate and estate administration process? And 3, how do you avoid making those mistakes? So we're going to attack those items and try to give you some sound advice. I will reiterate what Ashley said is please feel free to submit your questions through the chat box, and Eric and I will answer them at the end of the program. So what is probate and when is probate necessary? Well, a probate proceeding is necessary in order to validate your will. There's a common misconception that people say, well, I'm already appointed under the will. So-and-so or my parent or my husband or my wife appointed me executor, so I'm already executor. That is not true. You are nominated as executor under the will. When that person passes away, you need to offer that will to probate so that the will can be validated. And then once the court feels that the will was proper and valid, then you will be appointed executor and you will receive what's known as letters testamentary, which is a legal document with a raised seal that will empower you to act as the executor. So in order for that process to occur, there needs to be a court proceeding in the surrogate's court in the county in which the decedent resided, and documents such as a petition for the executor, along with other documents from the closest living blood relatives, will be submitted to the court. And then when the court reviews those documents along with the will, the executor will be appointed. Okay, so that is what probate is. The next part of this question is, when is probate necessary? Probate is necessary when the decedent had assets in his or her name alone. So if the person who passed away owned an asset in his name alone, say John Smith, then that asset will pass under his will, and you need to become John Smith's Smith's executor in order to access that asset. Okay, so that's what a probate asset is. It's an asset in the decedent's name alone. And the only person after death who has authority over that asset is the executor. A non-probate asset is an asset that passes outside of the will. It passes by operation of law, and the executor has no authority over that asset. Examples of that type of asset would be a bank account owned as joint tenants with right of survivorship, a beneficiary designation, say on an IRA or a life insurance policy, or assets held in a trust, because those documents already state where the asset goes upon death. So it's very important to look at what are the probate assets and the non-probate assets. Just as an aside, I want to mention one other thing that pertains to the common mistakes that we are going to talk about today. Those mistakes also can occur when there is not a will. In that event, an administrator is appointed. So the administrator is the same as an executor, but it just means that the administrator doesn't have a will to follow. The administrator follows the laws of intestacy in New York that says who can be the administrator and how the assets are to be distributed. So in the case of an administrator, letters of administration are issued, and that's the governing document that empowers the administrator. Okay, so that's what probate is and when probate is necessary.
So I want to talk about what are the common mistakes during probate and estate administration. But before I do that, I want to just address if you are an executor or a trustee and you've fallen into some of these mistakes, it's not the end of the world. Give us a call. Let's talk about the mistake and we'll help you resolve it and kind of right the ship. And our hope here is to advise you as to help you avoid these pitfalls and these mistakes. But if you're already in the process, we can help you overcome them as well. So some of the common mistakes are procrastination by the executor before and after they've been appointed. You want to hit the ground running and administer the estate as timely as possible. So you don't want to procrastinate. You could fail to marshal and manage the resources of the estate, and that's really kind of a fancy way of saying collecting the assets of the estate and making sure that it's not subject to waste or diminish in value unnecessarily or at the hands of you as the executor. You want to make sure that the payments and liabilities of the decedent and the estate are paid timely, and that the administration expenses of the estate are also paid. It's a problem when executors or fiduciaries in general fail to keep accurate accounting records, when they fail to communicate with the beneficiaries, and sometimes when people who are executors or trustees don't time the distribution of the assets to the beneficiaries appropriately. So you want to make sure you have proper timing of distribution of assets to beneficiaries, and also mishandling tax filings. That could be a big misstep that you want to either avoid, or if you are in that misstep right now, seek counsel to help you get out of that issue.
So as Eric has shown you, these are common mistakes and they can be rectified. And the answer to how do you prevent these mistakes or resolve these mistakes in terms of correcting them is to retain competent legal counsel to represent you. So, Ashley, I think you need to turn the slide one forward. There we go. Okay, so I'm going to concentrate on mistake number one, which is procrastination by the executor either before and or after qualification. Qualification meaning when you're appointed by the court. So you're nominated, like I said, under the will, but then you probate the will, and then when you qualify, you become the executor. Okay, so it's very important to have competent counsel because sometimes people are overwhelmed after somebody passes away, and often they're grieving and mourning. So, you know, it's very difficult to start to concentrate and focus on what your responsibilities are as a fiduciary. And I just point that out. When you serve as an executor or administrator, you're serving as a fiduciary. So you're going to have liability both as the fiduciary and personally. So it is absolutely imperative that you have legal counsel to represent you. So like Eric said, if you are already in the process, it's not too late. You can still seek the advice of counsel. Now, sometimes, you know, after somebody dies, you're just so overwhelmed that you don't know where to start and you don't do anything. So now you're delaying it. And sometimes that causes beneficiaries to compel the production of the will. And it's always not, you know, great to get off on a, you know, start that relationship as the executor as a result of somebody going to court to compel you to start acting. So that is why you need to just do the best you can to get legal advice as soon as possible. Other times clients think, well, I can get myself appointed, and they do so with the help of the court, and then they stall at that point. Now they've been appointed, but they don't know what to do next. So again, it's never too late to get the advice of counsel. What we do is when we initially meet with a client, whether it's immediately after the decedent passes or sometime thereafter, is we have a consultation. We send out a questionnaire ahead of time, and we ask the clients to complete that questionnaire. It's a little lengthy, but it's not complicated to do. And we also provide a list of documents to bring to the meeting. When we have a meeting, we have an in-depth consultation. We review the questionnaire, we review the documents that the nominated executor or executor brings to us, and we come up with what we call an action plan. That action plan will define the items and the duties and the responsibilities of what the executor. We will come up with a plan. Who's going to do it? How will it get done? And we will map that all out and create that roadmap, guidance and direction to the fiduciary as to what their liabilities are, what their responsibilities are, what their obligations are, what their duties are, so that it's very clear. And then we will assist you and walk you through that process to make sure that you are serving properly and making sure that you're complying with the wishes of the decedent. Within your responsibility as executor, you have many responsibilities. For example, Eric mentioned earlier, you have to collect and manage the assets. You have to make sure debts and administration expenses are paid. You have to make sure the taxes are paid. And then ultimately, when all that is done, you can distribute the assets to the beneficiaries in accordance with the will or in accordance with intestacy. But that is not at the beginning of the process. So we have to make sure that you act properly from day one, as soon as you're appointed, and then we will make sure that you do everything properly throughout the course of the administration of the estate, and ultimately to the distribution to the beneficiaries. Okay. Next item, mistake number 2, focusing on one of those duties that we were just talking about, is marshaling, which is collecting of the assets, and managing the assets. So again, you're a fiduciary, you're appointed by the court. It's your responsibility to make sure that you collect and preserve the assets of the estate. So you need to go through the decedent's papers, the decedent's tax returns for the last 3 years is what we recommend. Financial statements, monthly statements, the mail that comes through, and you have to take all of that together as pieces of the puzzle to put together a picture of what the decedent's financial situation looked like. So tangible personal property would be the assets in the house, and usually there's personal effects, and there's usually a provision in there in the will that states how you dispose of that. And there's also usually a provision in the will that states, well, if there's some kind of disagreement as executor, how you would resolve that issue. Then you need to look at what are the financial assets? Are there bank accounts? Are there brokerage accounts? Are there individually held stocks and bonds? Are there CDs? So you have to look at all of that. You have to look to see, was there life insurance? If so, was the life insurance payable to a beneficiary as a non-probate asset? Or is the life insurance payable to the estate? Was there real property? We have to make sure that the taxes are paid on the real property. As executor, you have to make sure that you keep the homeowner's insurance on that real property in effect, because God forbid, if there's some kind of casualty or damage, you need to have insurance on the property. You ultimately need to determine whether or not you're going to sell the property or transfer it by deed to a beneficiary. So this is all a fact gathering part of your duties as executor, to collect these assets and come up with what we usually then do is prepare a chart of what all the assets are, and then we keep records on that chart of the disposition of those assets. Now, that also applies to liabilities and debts owed to the decedent. We have to make sure we find out, did the decedent have any mortgages on the real property, home equity lines, possibly a reverse mortgage, credit card debt, medical bills, any kind of debts or liabilities that the decedent may have. As executor, you need to make sure those are valid, and then you have to provide for the payment of those liabilities. So that is what you have to do, in terms of information gathering up front. And then once you have all that information, from that point on until when you ultimately distribute to the beneficiaries, you have to make sure that you properly preserve, manage, and safeguard those assets. So if you have brokerage accounts, you may need to speak to an investment advisor. Again, like I said, with real property, you have to make sure the real estate taxes are paid so that you don't have any foreclosure issues. You have to deal with the mortgage companies. You have to make sure the real property remains insured. So those are the duties that you have to preserve and safeguard the assets of the estate. Okay, so at this point, we're going to go to mistake number 3.
Thanks, Marilena. So mistake number 3, payments of liability and administration expenses. Listen, no one likes to pay bills, but as a fiduciary, you have a responsibility to pay the debts of the decedent and the estate, and to pay the administration expenses of the estate from the estate assets. With that said, it's important to note that not every debt presented should be paid. You have to assess the validity of the claim. You want to make sure that if someone's going to come to you and say, oh, the decedent owed me money, well, let's take a look at the proof of the debt. Where's the promissory note? Is there a payment history that was made? Also, you want to check the terms of the loan to make sure that the estate is actually on the hook for the payment. Perhaps there's someone else who is jointly and severally liable for the debt, or that the decedent simply just guaranteed the loan and the borrower is actually still alive. So you want to be judicious in your assessment of the validity of the claims. And if there is any question of the validity of the claim, you could always go to the court to make sure that they can confirm that the debt needs to be paid and is valid. So pay the legitimate debts and expenses of the estate, but make sure that you're not paying something that you don't necessarily need to pay. With that said, you also want to make sure that you are paying them in the proper priority. So not every debt is an administration expense is created equal. So there is a priority under the law as to what payments need to be made first and then what comes last. So this is important in all estates, but it becomes much more important when there is a possibility of the estate being insolvent. So you want to make sure that you are paying those debts and administration expenses in order of that priority. So funeral and burial expenses, that's number 1. So if you have a family member, or maybe even you yourself as the fiduciary or individually paid the funeral expenses out of your own pocket, you want to make sure that you have confirmation of the expense and confirmation of the payment, and then you can make a reimbursement to yourself or to anybody else who paid the funeral or burial expenses. Administration of expenses of the estate, so this will be court filing fees, attorney fees, accounting fees, anything that will be needed to administer the estate, any expense that is incurred in the administration of the estate. Also, you want to make sure that you are paying the estate and personal taxes owed by the decedent. This has a priority here as well. Then you have medical bills relating to death or illness that was the cause of the death, and judgments and liens. So for instance, if the individual was on Medicaid, there's a Medicaid estate recovery that needs to be paid, or if there was any judgments owed against the decedent, that needs to be resolved and paid off and satisfied. And then you have secured debts like a mortgage or a home equity line of credit or home equity loan, or even auto loans. Those are secured by an asset of the estate, and they need to be paid off. Otherwise, you could have a foreclosure or you could have a repossession of a vehicle. And then comes unsecured debts. These are typically the last on the priority and need to be paid last in that priority. So for instance, credit card debt, you should not pay credit card debt first before these other expenses and liabilities are paid, because they are to be paid last. And a lot of times you could even negotiate the satisfaction or settlement of those debts, and you should make an attempt to do so. So again, not every debt presented should be paid, and not every debt is created equal. Next slide. Mistake number 4, failure to keep accurate accounting records. I think this is a very important thing to do, because as a fiduciary, you have an obligation to keep accurate records. And we see time and time again what I like to call the shopping bag executor, which is somebody who comes in with a shopping bag or a shoebox or a garbage bag filled with paperwork that they were able to find or acquire, and just kind of dump it on the table and say, this is the records that I've been keeping. And that's not a good idea at all. We assist clients with kind of sorting out these documentations and making sure that you are keeping accurate records. You need to establish an estate account, whether it's a bank account or a bank account and a brokerage account. You need an estate account to help marshal those resources and consolidate it into that account. And we assist our clients with doing so. And we help our clients with keeping track of their assets that they're collecting or marshaling, the income that they're receiving from those assets, and the expenses paid. And it's important to keep concurrent and accurate records of these assets, incomes, and liabilities, because as a fiduciary, you, number one, have an obligation to do so, but on a practical sense, if a beneficiary requests these, you have the obligation to provide these records. And if you're not keeping accurate records, you're going to find yourself in trouble. It could be time consuming and costly to go through and file an accounting or prepare an accounting after the fact when you should be doing it as you're going along. So the executor should have the documents ready to present to beneficiaries and to the court. Sometimes if a beneficiary is not satisfied with the records that you're keeping, or you're not keeping them sufficiently, then they can compel an accounting in the surrogate's court. And then you're in another court proceeding, which could be time consuming and expensive and very stressful, and could have been totally avoided had you just maintained the appropriate records. So,
and that perfectly leads into mistake number 5, which is failing to communicate with beneficiaries. So as an executor, you have a duty to make sure that you keep the beneficiaries updated during the course of the administration. And this is a mistake that happens sometimes, which is problematic, where the executor does not share the information. I'm not saying that all information is supposed to be shared, but there is certain information that needs to be shared. And when they don't, it can make beneficiaries feel uneasy, concerned that maybe something is not handled properly. So we always advise our executors that we have a duty to communicate with the beneficiaries, to keep them updated, to respond to reasonable questions, and to let them know the status of the course of the administration of the estate. We find that when you do that, it makes for happy beneficiaries, and it makes for the ability to informally settle an estate versus going into court for a judicial counting proceeding, or when beneficiaries commence litigation for other issues with regard to the estate against the executor. So, if you are timely, and if you are responsive and to the beneficiaries, and if you hire an attorney, as attorneys, we make sure you do that. It usually allows for beneficiaries and executors to have good relationships. Sometimes it's nice to have the attorney in between because sometimes there may be a little bit of a bumpy issue or something, or a little bit of discomfort, depending on, you know, what a beneficiary might think he or she is receiving and what the document actually says, which has nothing to do with the executor. The executor just has to enforce the wishes of the decedent. But it often helps to have an executor there to make sure that the beneficiaries are being responded to. When you do that, and if you keep the beneficiaries updated throughout the process, it, like I said, really makes it easier to do an informal settlement of the estate at the end. And that would be done with a document known as a receipt, release, refunding, and waiver agreement versus going into court. So if you could do it outside of court, it's always less expensive, and then the beneficiaries will receive more money that way. It's often quicker, and it's just an easier way to resolve and settle an estate. And Eric will talk more later about what that receipt, release, refunding, and waiver agreement document is, and the value to it. So I'm not going to get into that now. So our advice here is make sure that the beneficiaries are being updated. Now, if beneficiaries are represented by attorneys, as your attorney, we cannot speak to the beneficiary directly, but we will, in fact, deal with his or her attorney. Okay.
Elena, just to piggyback on that,
Yeah.
and if the beneficiaries have an attorney, you as the executor should not be communicating directly with that attorney. It should be attorney to attorney in that representation.
Absolutely. Excellent point. Sorry, I missed that. Absolutely. If you're represented by counsel, only your counsel should deal with any counsel of that beneficiary. You should not have direct communications.
A happy beneficiary is not a litigious beneficiary, so it's absolutely crucial
Exactly.
to make to communicate, make the effort. So, mistake number 6 is the proper timing of distributing assets to beneficiaries. So, timing is everything in life and in death and the administration of an estate. So, distributing an asset too soon could be very problematic from a practical and a legal perspective. So, for instance, you want to make sure that all the assets are collected before you make distributions of them, because then you're just going to have to do it again, make another distribution because there'll be more assets. Also, you want to make sure that all the claims are paid that are valid claims against the estate, because if you make the distribution of the resources, you're not going to have anything to pay the creditors, and then you're going to have to go back to the beneficiaries to ask them to refund it, and good luck, that might not be successful. So you want to, from a practical perspective, distribute the assets when it's appropriate. Try not to jump the gun. From a legal perspective, you want to limit or eliminate your personal liability. You're the fiduciary, you're doing a job, but you don't want your personal assets at stake if you make a mistake. So if you distribute assets prior to 7 months from the appointment of a fiduciary, so if it's preliminary letters testamentary, if you're just being appointed initially and then you get full letters testamentary, whenever you're appointed as a fiduciary, that's when the 7-month clock starts. And what's important to know about the 7-month clock is that if you make distributions of all of the assets of the estate, or a vast majority of the assets of the estate, and then an unknown creditor comes out of the woodworks and presents a valid claim, then the executor has to go out and get the beneficiaries to refund the assets of the estate. And if they are not able to do so, then they're personally held responsible for the debt of the estate. And that's not a position that we want our clients ever to be in. So it's important to wait out the 7 months to make sure that that any unknown creditors that come out of the woodworks are not going to hold you personally responsible for the debt in the event that you're not able to retrieve the assets of the estate that have been distributed. Now, it's important to note that there's a difference between unknown and known creditors. So that 7 months is only relevant as to unknown creditors, creditors that you could not have reasonably known about. However, if there are known creditors or creditors that you should reasonably know about, for instance, if there's a mortgage on the property, you should know about the mortgage, or if the decedent was on Medicaid and there's a Medicaid estate recovery, you should be aware of that. But if the known creditors, you have an obligation to make sure that those debts are satisfied. before you make the distribution of the resources. So that 7-month window is not relevant as to known creditors. Now, a document that Marilyn referenced before, which is, I think, crucial for any fiduciary, is a receipt, release, refunding, and waiver agreement. Now, these documents acknowledge the beneficiary signs these documents, and we recommend that you do not make a distribution, whether it's partial or final distribution of the resources of the estate, until you have a receipt, release, refunding, and waiver agreement signed by all beneficiaries of the estate that are residuary beneficiaries. So what is a receipt, release, refunding, and waiver agreement? A receipt, release, refunding, and waiver agreement is an agreement that the beneficiary signs, and they acknowledge the receipt of the asset, the inheritance. They release you from personal liability related to the estate. They agree to refund the estate in the event that there is a valid creditor that comes forth. And they waive the right to a judicial accounting against the estate. And these are all crucial to making sure that you're protected and that you're not going to be second guessed, or there's not going to be any issues in a legal perspective in the future. So you can kind of sleep well at night once these are signed. So this could be filed with the court, these receipt and release agreements, but oftentimes they are not. They are a mechanism to allow the estate to be administered informally. And if you have a beneficiary who's not willing to sign a receipt, release, refunding, and waiver agreement, or if you want concrete confirmation that this is never going to be a problematic for you in the future, then you would go forward with a formal judicial accounting and settle it formally with the court. But these receipt, release, refunding, and waiver agreements are used 9 times out of 10, probably 99 times out of 100 in estate administration cases, and they are very effective and very helpful in ensuring that you're going to be protected. Something that's also very important as to the timing is commissions. So as a fiduciary, you are entitled to a commission, provided that the will allows that, and provided that the trust agreement allows that. But if you are allowed a commission, you want to make sure that you take your commission if you're not waiving it, and you want to take it at the end, at the conclusion of the administration of the estate or the trust, because if you take it prior to the conclusion, then that's not allowed, and it could be a problem for you. So you don't want to distribute all the assets of the estate and then forget about your commission. Also, you want to make sure you're taking your commission at the appropriate time, so you're not depleting the assets of the estate unnecessarily or prematurely.
Eric, if I could just ask you a question with regard to the receipt, release, refunding, and waiver agreements. To make those, what I'll say, super valid and to be upheld in court, it's very important, and I go back to your shopping bag executor example, for your executor to keep good accounting books and records, because you usually attach as a schedule to that document an informal accounting, correct? Like a summary accounting?
Absolutely. The beneficiary needs to have disclosure, and they need to know what they're agreeing to. So the informal accounting, thank you for bringing it up, is absolutely crucial to the validity of the receipt, release, refunding, and waiver agreement. So not only are you going to give them a document and say, hey, you're not getting your money until you sign this, you're not going to do that. You're going to provide them with an informal accounting to let them know and let them be comfortable with the actions you've taken as the executor or trustee. And then this way they are knowingly and willingly signing this receipt and release agreement. And if they in the future say, oh, I was under duress, I didn't know what I was signing. Yes, they did. They had the informal accounting, and they had the opportunity to seek counsel to make sure that they knew what they were signing, and it was completely a valid document. So that's very important to know too. Thank you, Marilyn.
Yeah, and I only say that because Eric and I had a case a couple of years ago where we had rivalry brothers whose father passed away. We represented the brother who was the executor, and the other brother had counsel. And at the time, which was 5 years before the issue occurred, he signed various partial and ultimately final receipt, release, refunding, and waiver agreements. And then when the mother died 5 years later, he tried to reopen the father's estate in court. And Eric and I were successful showing the court that the brother had signed these documents, that accounting, informal accounting information, summary accounting was included, and the court upheld the documents, and we were successful on a motion to dismiss on that proceeding. So from the case law, those receipt and release and refunding and waiver agreements are, for lack of a better word, flimsy if they don't have the support behind it, because then how do you prove that the person knew what rights they were receiving, if those were the correct rights that they were receiving, and what they're waiving? So a very, very crucial document. That could be a mistake on its own, not having that document signed to protect you as executor.
Thank you.
All right, so that leads us to our last mistake, number 7, which is mishandling tax filings. And we've told you about the multitude of duties and responsibilities of executors, but here's another: taxes. So, going back to the first mistake, procrastinating. Well, if you procrastinate, you may miss some deadlines, and that's going to create interest and penalties to the estate, and that will be a problem for you. So I want to talk about 3 types of taxes that we need to look at when somebody passes away. And the first one I want to talk about is one that's very familiar to everybody, which is individual income tax returns. Every April 15th, everybody files their individual income tax returns, because as individuals, we are based on a calendar year of January 1st to December 31st, and we report our income. So in the year in which the decedent dies, the decedent will file a final income tax return from January 1st until the date of death. And it will be indicated on there that the decedent died, and this is a final income tax return. So that is the first type of issue. The next issue is what's known as an estate fiduciary income tax return. And that return is from the date of the decedent's death to either December 31st, if you're going on a calendar year, or to the last day of the month before the decedent's 1-year anniversary if you're going on a fiscal year. And that could be determined by the accountant based upon the income and the tax rates and which way is best. But what I want you to know here is the estate becomes an entity. When you probate the will and the executor is appointed, you have to apply for a tax ID number for the estate, which is just like a social security number. So then the estate has the requirement to file income tax returns every year that the estate is open. Okay. And the third type are estate tax returns, which we don't see as often as we had in the past because of the increased threshold amounts for federal and New York State. So currently, the federal amount is $11,580,000. So as long as you don't have that amount of money, you don't have to file until you have $11,580,001, then you have to file. So we're not seeing as many federal estate tax returns as we have in the past. For New York State has also upped its exemption to $5,850,000. So not seeing as many returns as in the past, but likely, there are several New York tax returns required for many, for many of our clients. So these returns are due 9 months from the date of death. So it's important that you have addressed a lot of the other mistakes that we talked about, which is gathering all the assets, having a big picture of what the financial situation of the decedent is, because you need to report that. So the estate tax return is a tax on the asset itself, not the income. So it's important that we make sure that everything is included on that tax return. The assets that were in the decedent's name receive a step-up in basis. So an example of that would be if the decedent owned a piece of real property, say a house that they bought for $50,000 when, in 1960, and now in 2020 it's worth $500,000. The basis in that property is stepped up to the value as of date of death. And the only other comment I just want to mention here is that we do not have an inheritance tax in New York, which means that the beneficiaries of the estate who inherit don't pay a tax on the principal, the assets that come to them. They'll have to pay a tax on the income that those assets generate once they become the owner of it, but they do not have to pay an inheritance tax. Okay, and you have to look at the will, and the will say how the estate taxes get paid. Sometimes it's paid off the top, sometimes it's paid pro rata share based upon the beneficiary's inheritance amounts. So you definitely need to have an attorney and or an accountant involved to make sure that you file these tax returns properly and timely.
Thank you, Marilena. I just want to remind the attendees to submit your questions through the chat or the Q&A, and we're happy to go through the Q&A in a little bit, but I just want to explain how our law firm can help you as a fiduciary. So we routinely inform the executor about the estate administration process, and as Marilena mentioned earlier, we have a very in-depth meeting initially to go through all the legal documents, to review the known assets and the known debts that are in existence, and we advise our clients about the process and explain how we can guide them through it and create that action plan that's so crucial. We advise the executor about his or her duties and prepare and file the appropriate court documents, which essentially is we help our clients get appointed as a fiduciary, as the executor, or as the trustee of the trust under the terms of the will. And then we continue to guide them to ensure that they are honoring their obligations to the court, because it doesn't just end with your appointment as the executor or the trustee. You have to continuously make sure that you're honoring your obligations to the court, and any subsequent proceeding that gets brought you respond to. So we guide our clients in that regard. We also help them prepare and file the appropriate tax returns and ensure that the tax payments are made on a timely basis. So it's important to have a tax preparer, but a lot of times it makes sense for our firm to prepare the returns internally to make sure that they're done properly, especially if it's a complicated matter. And at the very least, we will work with your tax preparer and review the tax returns to make sure that they're done correctly, and to make sure that any and all tax liabilities are paid on a timely basis. So we also assist our clients in minimizing taxes and ensure the proper disposition of the assets. So you want to make sure that you're paying the least amount of taxes, taking advantage of all of the deductions that are available, and that you're just distributing the resources of the estate to the beneficiaries in a timely manner. As we mentioned before, we want happy beneficiaries. So we also assist our clients with resolving family disputes. Now, with that said, oftentimes we'll have family meetings to kind of bring everybody to the table and discuss what's going on with the estate administration, address any open questions or concerns among the family or among the beneficiaries before they become points of litigation. The idea here is to prevent family disputes from becoming costly litigation, and I like to make sure that the families I work with, they don't allow any disputes they may have to result in preventing them from eating Thanksgiving dinner together. So you want to resolve the family disputes, and we're pretty successful in helping do so oftentimes. We also analyze the interrelation of the estate, individual income tax, and fiduciary income taxes. So as Marilena mentioned earlier, there are three essential types of tax returns that need to be filed in a lot of cases. And there are a lot of different rules related to each type of income tax, what deduction can be taken or cannot be taken, whether something is going to be reported as income, or if it's an estate, if it's an asset. So you want to make sure that you're taking a big picture view of these tax returns and these tax liabilities, and making sure that you're having them prepared properly and taking advantage of all the opportunities you have to minimize the tax liabilities. And we're very successful in assisting our clients with doing that. And also, last but not least, implementing estate planning for beneficiaries, such as a surviving spouse. A lot of times when someone passes away, that is going to impact the estate plan for the surviving spouse or any other beneficiary. So we like to review the estate plan and make sure that the death of the loved one is not going to impact it so much that it's no longer relevant, or it needs to be updated to make sure that your needs and wishes are met. So it is important to take a look at your estate plan after you have a loved one that passes, especially if they're crucial or integral to the estate plan.
You know, Eric, if I could just add a comment off of that,
Sure.
is sometimes, you know, I think what you were addressing here is beneficiaries updating their estate plan, such as a surviving spouse, now that, you know, their spouse died, you know, and maybe their advance directives need to be updated because their spouse can't be their agent under the power of attorney or their healthcare proxy agent. Or their will provides for their husband first and then children. So yes, it can be updated. It should be updated in those regards, but I also want to point out something known as post-mortem estate tax planning. And for larger estates, sometimes it makes sense to for a beneficiary not to receive all or part of his or her inheritance. And there are time frames under which that has to be made, those qualified disclaimers. That's usually within 9 months from date of death. So that's something that we would want to make sure that we talk to you about initially, because once you act on an asset or derive any kind of benefit from it, you've tainted that asset, so you lose the ability to plan with it. So that is definitely something, you know, that you should, as a beneficiary, should speak to an attorney about as well.
Absolutely. Also, if you think about it, also long-term care planning, if you're inheriting a lot of property and you're either on government benefits or you foresee the need to be on government benefits such as Medicaid,
Yep.
you're going to need to do some long-term care planning, and the inheritance that you've just received is going to impact that. So it makes absolute sense to review your estate plan and try to come up with a game plan that works best for you as a beneficiary.
Absolutely.
Okay, so the question is, what do I do now? So what I suggest you do is, number one, create an action plan, and then retain the services of an experienced trust and estate administration attorney at Russo Law Group, and then implement the action plan to ensure that the proper administration of your loved one's estate occurs while protecting you as the fiduciary. So create a plan, retain the services of a professional, and get your plan implemented.
Okay, I think we have a couple of questions. I will read the first one. My father passed earlier this year and did not have a will. An administrator has been assigned in Oklahoma, where my father was living when he passed. This attorney is asking my siblings and I to complete a waiver of notice, accounting, general inventory and appraisal, and consent to the sale estate document. Is this common? What should I be aware of if we do complete this form? So first, let me express my condolences to you, number one. And then number two, I am assuming your father was domiciled in Oklahoma. I don't know who his executor is. These documents sound familiar to some of the documents in New York, but I honestly, and Eric would agree with me, unless you say something differently, Eric, we cannot answer this question. What we can do is help you find an attorney in Oklahoma who could answer those questions for you, representing you as a beneficiary. Because when you sign these documents, you may be waiving some rights that you have that once you sign those documents, you can't change your mind with. So to the person, and we have your name here, but I'm not going to say it online here, but if you wish to get a referral to an Oklahoma attorney, we're happy to help you with that.
I completely agree with you, Marlena. Unfortunately, you know, we are New York, not unfortunately, fortunately, we're New York attorneys, but unfortunately in this situation, we're not licensed to practice in Oklahoma, and you'd be better served to meet with an estate attorney in that state. One of the benefits that Marlena and I have as board being on the board of directors and former board of directors of the National Academy of Elder Law Attorneys is we have a wide network of referral sources to other attorneys in other states. So if you have an issue or something comes up with involving another state, give us a call. Let's talk about it. Let's see who we could put you in touch with to make sure that your problem is being addressed.
Excellent. Okay, the next question, well, it's a series of questions here, Eric, so you may want to take notes as I ask them. Okay, so first question here. How complicated is the probate process when a non-spousal relative, for example, a niece or nephew, inherits a co-op apartment that could not be included in the decedent's revocable trust?
So
That's the first part of several questions.
you want to take it all at once or go one by one?
Yeah, I say let's take it one by one.
I agree. So the probate process is as complicated as the facts and circumstances related to the decedent. So if you have a contentious, set of characters that are involved in the probate process, then it could be complicated. However, if everybody's willing to sign off on a waiver and consent, and the probate petition is filed and prepared appropriately by experienced counsel, then it should not be so complicated. But it could be. It really depends on their circumstances.
Right. If it's uncontested, it's not as complicated. If it's contested, that's another situation. Okay. Next question. What are the tax consequences for the estate? Well, I think we kind of touched on that already when we talked about the taxes that affect the estate, and that would be the estate fiduciary income taxes and estate taxes depending on the value of the gross estate. All right, next question. What are the estimated attorney's fees? Eric, do you want to take that one?
So sure. The estimated attorney's fees, it really depends, again, on the circumstances. And I know it kind of seems like we're sidestepping the answer to the question, but it really is a truth. We can't give you a realistic and appropriate sense of the costs involved without having all the facts and having a clear understanding of what the action plan is and how best to address it. So I think that there's a range, and it depends on the circumstances.
And certainly a contested estate is going to be more costly than an uncontested estate.
Absolutely.
Okay, what are the tax consequences for the person who inherits the property? Well, I think we answered that already. There is no inheritance tax in New York State. So the person inheriting does not pay a tax on the receipt of those assets. However, the person who inherits will be responsible to pay income tax on any income generated by those assets. Okay, last question here. Going back to the co-op, will probating the co-op delay implementing the revocable trust and/or settling the estate as a whole? And the answer to that, and then I'll let Eric put his 2 cents in. The answer to that is, well, the person who is inheriting the co-op, where is it happening from? Like, for example, is the person inheriting it under the will? And if that's the case, then the co-op under the will won't affect the timing on the revocable trust. However, if the co-op was a probate asset under the decedent's will, and the decedent's will is a pour-over will to that revocable trust, then that will delay the administration of the revocable trust. Eric, do you have any comments on that?
That's exactly what I was thinking in that case. If it's a pour-over will, then you have to hold off on the distribution of the revocable trust, at least in the conclusion of it, to get the assets of the estate. But if not, you really just have to honor and distribute the resources pursuant to the terms of the will.
Okay. Ashley, do we have any other questions?
Yes, Maria Elena, we had one come through on Facebook, actually.
Okay, great.
So, yeah,
Great.
The question's from Lisa. And it's, does a will have to be filed with the court once it's created or updated? Or is it enough to have it signed in front of witnesses and notarized?
Eric, do you want that, or should
Yeah, so I think we need to just dissect the question just a bit. So in order for the will to be valid, it needs to be executed in the presence of two witnesses, and the affidavit of the witnesses need to be notarized, but not necessarily the actual will itself. So it needs to be witnessed and notarized, the document, for it to be valid. However, it doesn't necessarily need to be filed with the court once it's created or updated. And oftentimes people will hold on to it, or they'll have their lawyers hold on to their original will and not submit it to the court. Once you submit it to the court, it becomes a matter of public record, and you may not want that to be public record. You certainly could submit it to the will during your lifetime, but it's not a necessity.
And as Eric said, when we draft a will and have our clients execute it, if they wish, we hold that in a safe so that, you know, it's here with us for when the time comes. And we provide them with a copy with a notation on it that says, you know, that we're holding the original will for safekeeping. But recall, you know, just remember that a will, only what I said from the very beginning in when I was telling you what probate was, a will is only probated when you have assets in the decedent's name alone. So if there were no assets in the decedent's name alone, the will doesn't get probated. And again, the person is only nominated in the will, and it's not until probate is completed that the executor is truly appointed.
Well said.
Excellent. Ashley, any other questions?
Yeah, I think we have time for one more, and then we'll need to probably wrap up our Q&A session here.
Okay.
But Richard's asking, if I am the executor, is it best to use the decedent's attorney or Russo's?
That's kind of
Good
a loaded
question. We'll try to give a
Fair response.
yeah, you want me to take that one? So,
Sure.
you know, it really depends. Honestly, it depends. You know, we're not limited to representing executors solely for decedents for whom we drafted wills and trusts. We represent many clients as fiduciaries for documents drafted by other attorneys. Often, the attorney who drafted that will may have some information in his or her files that is helpful. So it's really a choice of you know, your comfort level. What I tell clients all the time is we represent you as executor or you as trustee, meaning our job is to protect you because you have liability. So it's really going to be a decision as to, you know, which attorney do you feel comfortable with, and do you feel is experienced to, you know, protect you in your service as the fiduciary.
I just want to add that it's important to just be aware of the expert, you know, the experience level of the person who created the will, because it may just be something they did as an ancillary part of their practice, as an accommodation, and they may not be a trust and estate attorney. So just be aware of that and ask the you know, some questions to confirm that information.
Excellent point.
So what makes Russo Law Group different? On that note, what makes Russo Law Group different? We have information and resources at our website that we would love for you to take advantage of at vjrussolaw.com. And we've been helping thousands of clients all throughout you know, New York City and Long Island for over 30 years, Marilena?
Oh yeah,
short?
since I guess I'm thinking since 1988 or 1989. So yeah, for
Okay.
quite some time.
And we also are reaching out, just to let you know, to frontline workers who need assistance with their estate plan on a pro bono basis. So please give us a call at 516-683-1717 if you are a frontline worker or you know someone who's a frontline worker and needed assistance with their estate plan. We try our best to give back to the community and honor those who honor you know, the people who need assistance. So that's just one of the reasons why we are different than many other law firms. So Ashley, you want to talk about some upcoming programs?
Sure. Our next Facebook Live webinar is on September the 15th It's federal estate tax planning. It's part of our estate tax planning series presented by the Vincent J. Russo. He is our managing partner. So if you're not already registered for this series, you can go ahead and sign up now. I will send the registration link through the Zoom chat window. Hopefully everybody sees that on their screen. That series will round out on October the 20th with a presentation on estate tax planning for married couples. And finally, if you're a healthcare professional or maybe you know of one, we are hosting virtually the 29th annual Elder Law Conference for Healthcare Professionals, and that's taking place on September the 16th. So let us know if you'd like more information on any of our upcoming programs. Also, just a quick note, a survey will open in your web browser once you leave the webinar. So please take just a minute or two and let us know your thoughts about our program today. And that's all
Ashley,
I got.
okay, could you just share with everybody where our offices are located?
Sure. So we have 4 convenient office locations on Long Island. We're in Manhattan. We are also on Lido Beach. We've got an office in Islandia and Garden City.
And as Eric said earlier, we have relationships with other attorneys throughout the country. So, we are available to, assist you and put you in the right direction so that you get the legal representation that you need. We view our clients not as transactions, but we create relationships. So we are here for you, whatever your needs are. If we can help you, we will. If not, we will try to get you in touch with somebody that can. And Eric and I would just like to thank all of you for attending today.
Thank you so much, everybody.
Thanks. Bye.
Have a great day.
Bye.